Hello, welcome again. This is Maciej Gawroński, GDPR lawyer and expert. We are responding here to questions concerning data protection in the European Union, or maybe sometimes more generally. Now, we have been asked a very fundamental question. When do I have to report a data loss or data breach? Well, it will not be probably easy to answer this question in a short time unit and to give a simple answer, because it's generally not easy to give simple answers to GDPR. However, I will try. There are two regulations, actually Article 33 and Article 34, which relate to personal data breach. I will then get to what is a personal data breach. But when do I report data loss or data breach? Well, I report it to a supervising authority almost always. So I report it unless it's unlikely that the loss constitutes a risk to rights or freedoms of persons whose data have been breached. However, if not only there is a risk, but the risk to these rights and freedoms is high, then I also need to inform and notify these particular persons who have been affected. This is the simple answer. But then we've got a number of these qualifiers. First qualifier, what is a data breach? So actually, when we are controlling personal data, anything which happens with the data, which is not our intentional and lawful act, would then probably amount to a personal data breach. So if we lose data, if they are destroyed, if somebody else accesses the data, and if the data become corrupted, so something changes there, then all that amounts to a personal data breach. Because personal data breach is actually a breach of security of information which constitutes personal data. And this security, usually we see it through three attributes, which are confidentiality, integrity, and availability, which can be easily memorized by the three-letter acronym CIA. All right, so first of all, we are losing data, or somebody is accessing data, because it's not the same. First of all, it means that we cannot use the data in a proper manner, intended manner. And secondly, that somebody else is capable of accessing data and using it in an unauthorized manner. So when do we report, or when do we notify? Then we've got this qualifier: risk to rights and freedoms of individuals. So if there is something wrong which can happen to a particular person because of a personal data loss or breach, then there is a risk to that person's rights or freedoms. So notification to the supervising authority should be, by definition, a first step, and probably we should rather notify them. When can we resign from notifying the supervising authority? When it's unlikely that that loss or that breach would have negative consequences for persons affected. I mean, persons whose data has been breached, let's say. How could it be established? Let's say we've got a laptop which is very strongly protected by full hard drive, strong encryption. And we are losing the laptop, either because we've lost it somewhere, or even somebody stole it from us. In the second situation, it's a little more complicated. But the circumstances of the case do not raise a suspicion that it's been a theft of data, but more like it's a theft of property In this case, we can consider whether the risk to these persons whose data have been on the computer is not high. However, again, then we need to take into consideration what type of data has been on this particular laptop, whether they were highly sensitive, and I don't necessarily mean sensitive in the meaning of the GDPR, but more general, or not. And there's also the problem that if you've got a laptop and any other device which actually contains our mailbox, then we have all sorts of data there. Not so easy to say that it's unlikely that the loss of particular data or a loss of its data career, would not generate a risk to rights or freedoms of these particular persons, which would easier say, wouldn't pose a risk to these people whose data have been breached. Then there is also this question, how high is the risk? Because if the risk is high, then we also need to notify people around. Supervising authorities, they have a tendency to obviously, maybe not to exaggerate, but to estimate the risk more towards the higher values than to lower ones. So from this perspective, for instance, if somebody has access to personal identification number of another person because we have addressed the correspondence wrongly, then the data protection authority might say the risk is high because of the knowledge of and possession of this personal identification number. An unintended receiver of the information can, for instance, use it to borrow money actually to steal somebody else's identity. Well, in what we say in the situation is, well, how likely is that this information actually reached a thief? Which part of the population of potential unintended recipients actually are thieves? So we get into a lot of statistics. Well, we need to calculate the likelihood. And it's not very easy, neither for small data controllers nor for big data controllers. However, these calculations of whether the risk is unlikely or whether it's high, for bigger data controllers, it should probably be somehow quantifiable and quantified. Otherwise, it's difficult actually to prove consistency in evaluation. We have developed such tools which are now taking form from an Excel spreadsheet of an application. Soon probably we will share it because an Excel spreadsheet, we've already shared it at least locally with some of our community, and we'll be probably sharing it more widely. So you would be then kindly invited to check let's say the factors that we've put to these evaluations. For small entities, obviously they can also refer to for these quantifiable methods. So, but they can also rely on their own thinking and their own, let's say, more narrative explanation of the reasoning. It's fair enough. However, in each case, it needs to be documented. It needs to be documented, and we don't have much time to do this because this initial report to the supervising authority should happen within 72 hours from the moment the breach is detected. It does not necessarily mean that we can then wait another 2 weeks, for instance, before notifying data subjects whose data have been affected, because it may be even otherwise. If, for instance, we have lost highly sensitive data or data relating to authentication, so logins and passwords, which have been stored in plain text. No, never do this. Never store passwords in plain text. It's absolutely forbidden. So anyway, if this happens, we should probably start with telling all people around that they should immediately change their passwords. This is the law in theory. In practice, it rarely happens. But then if we don't do this, we may expect a higher fine from the supervising authority. Well, I hope at least you've got the first feeling of how sensitive the problem is. Thank you very much.